Welcome to Justice Arena.
Your name is different on the sheet, so you prefer Perry?
Yes, that's my married name.
Okay. Miss Gloria Perry appears plaintiff in this matter. Miss Perry, good morning.
Good morning.
And Wesley Carter joins us, the defendant in this matter. Mr. Carter, good morning.
Good morning, Your Honor.
I have read your motion. Is there anything you'd like to add, accentuate, highlight, and then we'll hear from Miss Perry?
No, I mean, the motion was pretty cut and dry, basically. But I would like to just say I would like to extend a heartfelt thank you to Gloria for being here and allowing this to take place and taking time out of her day. And thank you for being here, Your Honor. So, like I said, the motion is pretty cut and dry. So other than that, I don't really have anything else to add.
Okay, I certainly might, but go ahead. Ms. Perry, anything you want to add?
No, Your Honor. I am actually a little surprised with this. I didn't realize that this was something that could be asked of. As far as the motion itself, I think I received $62 a month. And I'm just shocked that this is being presented. So no, I'm just eager to hear what you have to say about this.
Well, I'm eager to hear what you have to say about this. I mean, he is requesting that I forgive a boatload of arrears, some of which are owed to you. And I'm curious as to what your...
Oh, I didn't agree to anything. I don't know if that's what's been stated, but I didn't agree to anything.
No, I know that. That's why you're here. I'm trying to ask what your position is on these for the record, because I don't have any position from you at this point.
My position is, honestly, I went through hardships with my children. Mr. Carter was not involved with them growing up, so I struggled a lot in my younger years. I'm doing very well now. I think if anything, I'm willing to, settle with a smaller amount if Mr. Carter is willing to agree to that. But ultimately, I'm not willing to dismiss it completely.
Well, let me explain how this works. You make some interesting points in your motion, but let me first of all give you kind of a lay of the land. First of all, you owe arrears to Miss Perry in the amount of $36,359.80. That's what you owe Miss Perry. You also owe $13,578.39 to the state of Michigan. You also owe $1,275.50 to the Kent County. So what I can do and what I can't do, I can't waive arrears owed to either the state of Michigan. That has to be waived by the Attorney General. I can't waive any fees or any of that owed to Mom because that's her money, not mine. I can't do that. Now, I could conceivably forgive or waive the $1,275.50 to Kent County, but I would need more information on that from you. But I think what you are going to have to do, Mr. Carter, is I think you're going to have to try and reach some sort of an agreement with Ms. Perry, because that's got the bulk of it. Then the $13,000 left to the state of Michigan, you could probably find a sympathetic soul in Lansing who would give you a break on that as well. And then once those things are done, if all you have left is the $1,200 owed to the county, I would probably toss that in. The problem you also have is because I checked on this, and the passport issue is not only being held by Kent County, but it's being held by the state of California. Okay. And the state of California, at least I'm told anyway, and I don't know because I don't practice there, never did, that they are very reluctant to give passports back until the parties have straightened out the arrears. So if you can get the situation to with Miss Perry resolved, the situation with the state resolved, and the issue of passport with California, come back here and I can probably do business with you on the $1,200 you owe Kent County. And then I may even be in a position to give you back your passport. But right now, even an order giving it back to you wouldn't do any good because California is holding on to it. Does that make sense to you?
Of course.
Okay. So that's kind of the route I'll follow. I'll deny your motion without prejudice, meaning you can bring it back here, but you've got some people and issues to deal with first, and then you can come back here. Okay?
Sounds good.
Nice to see you both.
Thank you.
Thank you, Your Honor.
You bet. You're all set. So, Mr. Smith, I read your motion regarding child support. Let me ask you, Ms. Williams, if you got a copy of Mr. Smith's motion.
Yes, I did.
Okay. I read it, Mr. Smith. Let me tell you what I know, and then I'll hear from you. So on January 19 of 2024, this court ordered the front of the court to review child support, which was last entered by a uniform child support order dated September 27, 2023, in the amount of $551 per month. The front of the court completed their new review and recommended no change. And actually, it went up $40. But see, if it doesn't affect it $50 up or down, they will not change support. So they completed their review, and there was no change. Now, I've had quite a few cases today that, and I can tell everybody this, that in a perfect world, everybody would take into account everybody's bills. Okay, they would say, okay, this is how much he pays for this. This is how much he pays for this, and but they don't, because the laws in this state basically say all your other bills are secondary to child support. And I didn't write the law, obviously, but I have to enforce it. So I can't grant your motion to change support unless there's been a substantial change of circumstance. If your income has gone up, if you've had another, or down, if you've had another child, if the other side's income has gone up or down, those are what they call substantial changes of circumstance. Otherwise, you have to wait until 2027 before you can do it on your own. But like I said, if there's been a substantial change of your circumstances, not counting the bills, I can't do anything about. But if it has to do with your income, the amount of overnights, other children, that's type of stuff, I might be able to get the friend of the court to do something else. But I don't see any of those things in your motion. All it says is I need to pay my bills, and unfortunately, I agree with you 100. Hang on, I agree with you 100%. But there's not much I can do about people's bills. Go ahead.
No, listen. I understand, that my child being there, that $500 due to bills and all that, it probably won't even scratch what her bills is, knowing her. Only thing I'm asking is to reduce not touching my little check, my hearse. I'm getting both checks being taken out. My big job can take care of my whole child support. Only thing I'm asking is just not touch my little check, hers. I don't care about not paying the money. She deserved that. I'm just asking to not touch the little check.
Okay. So I'll tell you what the law is on that. I cannot force you, nobody can, to work 2 jobs. Can't ever force somebody to do that. Just like I can't force anybody to work overtime. I can't do that either. All I can do is the 40-hour main job. The problem is when you do that, when you do work overtime or you do have a second job, they count it as income for child support. And I don't know, there's not a way I can say, don't touch that. I wish I could, but they can't force you to work 2 jobs. But if you do, they have to count it. Okay, that's unfortunate, but that's how I wish I could do whatever I wanted to here because I'd have a lot more happier people today than I do already. But Ms. Williams, what are your thoughts?
Well, I agree with the child support that's now. I mean, I could ask for more, but I guess what he's paying is good enough right now. But I do want to know why he never asked for parenting time. He hasn't seen her in over 2 years.
Yeah, I know that's
longer than that.
and I know that's on your mind, but unfortunately, all I can cover is the motion relative to child support. I can't cover the parenting time aspect because that's not in front of me. But
Okay.
if somebody brought a motion regarding parenting time, I can't make people do or be great mothers or great fathers or do this, anything. I can't. I wish I could. But because parenting time actually is one way that parties can reduce their child support, because the more overnights you have a child, the less stress it is on you. And because you wouldn't have to, the theory is anyway, that if somebody has overnight
I'm with that. I'm with that. Now that I'm stable, I have my own apartment. I'm with that. You know what I'm saying? I'm with to come to agreement with the overnights. So yeah,
you want to,
she right.
what you have to do. Well, hang on. We have to do this right, folks. You can't do it just haphazardly. The way you do that is you would have to file a motion to review parenting time. And if you do, I will promise you I'll take a look at it. And if you and Ms. Williams come to an agreement on parenting time and it sounds good to me, I'll enter it into an order. If the parties need some help, I would send it to the friend of the court and let them make a recommendation to me about parenting time. But I can only do what I got in front of me, and that's child support. Okay? So
Yes.
I can respectfully deny your motion, but I really appreciate meeting both of you. I wish you the best. I hope this parenting time situation gets resolved, but you can both sign off. We're adjourned. Thank you.
Thank you.
The defendant in this matter, Brittany Avery. Ms. Avery, good morning to you.
Good morning.
So I have read your motion, Mr. Cox, and I have also read the response by Ms. Wagoner. Let me start with you, Mr. Cox. Is there anything you want to add to it, accentuate, highlight that you don't think I already know? And then we'll hear from Ms. Wagoner.
Thank you, Your Honor. Unfortunately, I'll be brief because I know that, as always, you read everything very thoroughly, and I'll just make 2 points, Your Honor. One is that the previous order clearly says that there will be an automatic review of parenting time in 1 year, meaning either party can bring this before the court to review parenting time without a proper cause or change of circumstances. That's point number one. Point number two, and I'm going to shut up, Your Honor. Point number two is Ms. Wagoner and I have a very strong proclivity to settle cases together. This case seems to be screaming for mediation, Your Honor, and that's just my thought on that. And I'll give you back to the floor.
Thank you, Ms. Wagoner.
Your Honor, I also know you read my response, so I don't necessarily have anything to add. I normally am a strong proponent of mediation. I'm not sure that my client's position would be agreeable to changing any type of parenting time at this point, hence our request to ask to deny the motion. And so I would just simply follow the rest of my prayer for relief.
Thank you. Well, mediation is one of those odd things that I always take what the attorneys tell me as far as that goes, and I always ask them if mediation. I know I can send virtually anything pursuant to MCR 3.216 to mediation, but I also don't want it to be a complete waste of time. Here's what I know. The last parenting time order was dated not that long ago, August 29 of this year, which provided to the parties an automatic threshold determination based on either party's request. Not quite sure how I feel about those. I'm sort of, it seems like that is kind of an interesting perspective as far as what courts need to find as far as threshold, but I won't, as I did not sign that order because when this first came up and I saw it, I'm going, I would have never signed it, but I saw Judge Gottlieb did. And so I will reluctantly find that based upon the simple request of the parties, that I will send the matter to the friend of the court for an investigation recommendation relative to parenting time. The fees will be split. One of the things that caught my eye in not only the motion, but in the response is this whole issue of counseling. And I somewhat got the impression that the parties think that the children, I use their initials, JDZ, who I think is 10 now, right? And LAZ, who is 9. I think JDZ is going to be 10 only for a short time longer. But I think there was mention of counseling. I'm pretty standard with that as far as counseling. If the parties feel that children need counseling, I tell them to go pick a counselor. If they don't agree with it or can't agree on who should be the counselor, then the attorneys can submit a couple of names to me, and I'll draw them randomly, and that will be the one. The last thing I want to tell you before I send you on your way with the order of reference is, extracurricular activities are not legal custody decisions, and I don't spend a whole lot of time dealing with those in the context of parent squabbles. I'm pretty consistent with this too. When you've been doing this as long as I have, you kind of get a tell, and your attorneys will know that better than anybody, that my theory or my position on extracurricular activities is your time and your dime. And that's how I look at extracurricular activities in the future. So maybe if that helps guide the discussions going forward. I will obviously reserve the issue of mediation if Mr. Cox and Ms. Wagoner, who are two excellent attorneys, come to the conclusion that, yeah, maybe it'll help. I certainly have no problem doing that, but I will wait to hear from them. So in the meantime, I will send it to the front of the court. Fees will be split, and I will sign that order today. Mr. Cox, anything else I can do for you?
Nothing further, Your Honor. Thank you. Have a good weekend.
You too. Ms. Wagoner, how about you?
Nothing further. Thank you.
Thank you both, Mr. Zamora, Ms. Avery. Best of luck to both of you going forward as you discuss some difficult issues coming up. We're adjourned on that one.
Thank you, Your Honor.